Thank you so much for staying on that channel. This is Law School Made Easy at Law School Made Easy 256. We want to thank you for the subscriptions. Thank you for subscribing, but keep subscribing. Look at down this video, there is a subscription button. Please keep subscribing for more and more of these videos. I want us to enter straight into contract law today, and specifically we are going to look at offer. But of course, I cannot go in on offer minus telling you the definition of what a contract is, so that at least it has to be in your heads as first year students learning counsel. In first year, you must know how a contract is defined. But we're all defining most of these concepts. All concepts which have been provided for in the law endeavor to define following the law, and Section 2 of the Contract Act clearly defines contract acts as an agreement that is enforceable by law. We are looking at an agreement which is enforceable by law. So I want to give an example. Just think about it. I don't need an answer. Think about it. If I contract, let's say, if I contract Muzamiru to go and kill, let's say, Sheila. So I promise Muzamiru 100,000. I give them 20,000, and their balance is 80,000. Muzamiru successfully kills Sheila and then comes back requesting for his balance. I refuse to give him balance. Can Muzamiru sue? Can he go and report to police? Can he sue? I know you know the answer. So in my opinion, Muzamiru cannot sue, simply because the agreement we entered into is not enforceable by law. So a contract is that agreement you enter into when you can be able to enforce it. So colleagues, as you enter contracts elsewhere, ensure that you can enforce that contract. However, the Contract Act further defines, expounds on the elements which form a contract. And those elements are very simple. One of them, they say in Section 10, Contract Act is an agreement made with a free consent. There must be free consent, no duress. You enter the contract willingly. I know the learning councils now, by the time you finish your first year, you would have addressed your mind to Section 11, Section 10, and Section 19, and very many others. We are saying an agreement entered in with free consent of the mind, with capacity to contract. You must contract with somebody who is capable, who is allowed by law to contract. And then for a lawful consideration, there must be loss and benefit, but that lawful consideration must be lawful, okay? And then with a lawful object, with intentions to create legal bounds. So that is the definition of a contract. But today we want to look at just one element, and that is the offer. The Contract Act Section 2 further defines an offer. So I urge you to go and read the Contract Act Section 2, defines an offer as a willingness to do. That there is somebody who is willing to offer, to give an offer, to give something. There's somebody willing to give something. I'm willing to offer my land for sale. So the moment I offer, these are the common principles governing offer. The moment there is an offer, then I expect acceptance. If somebody accepts, then that means they have accepted to be bound by this offer, which this agreement which we are going to sign. But today particularly, we want to look at the wordings, the advertisement, the different advertisement, and that will take us to a case of Carlill and the Carbolic smoke ball, and then we shall also look at the case of Romera Nalongo versus Wales Town Council, and we shall break through to the case of Chimona versus the Asia Departed Custodian Board. So those are the three cases we want to look at, and lastly, we shall also look at the case of Harris versus Nickerson. So those are the four cases we want to differentiate in terms of wording of advertisement, in terms of those offers which are put on the wordings. We want to differentiate that, is this wording in an advertisement an offer, or it is an invitation to treat, or there is a condition a condition offer, or is it a condition offer? So let's go straight to the case of Carlill and the Carbolic smoke ball. The Carbolic smoke ball, they put up an advert that whoever bought the smoke ball and used it in the prescribed manner would get a reward of $100. They did not stop there. They put $1,000 in Alliance Bank as commitment to show their sincerity. So this one woman, Carlill, goes and buys this Carbolic smoke ball and uses it as prescribed. But later, she catches influenza. So she demands. On demanding, when they went to court, the counsel for the Carbolic smoke ball was very clear at saying, there was no offer. We cannot make an offer to the whole world. Secondly, there was no acceptance. That Carlill never notified us that she had accepted. So that was the argument. And again, they said it was a mere commercial puff. Exaggeration, a mere commercial puff. They were exaggerating. Allow me, I know there are colleagues who are watching from the central region, and you know Luganda very well. I'll put in a word just to break this. Some of you have heard adverts on radio saying that the first 1,000 will get a stick of meat. Will get a stick of meat. That is a wording of advertisement. But so what is the meaning of that wording? So we are focusing on this wording. But Carlill is a special case. So in the ruling, Judge Bowen, the lead judge in that case, Judge Bowen, stated these facts, that an offer can be made to the whole world. And that is what members will call a unilateral offer. One person can make an offer and it is made to the whole world, the way it was in Carlill, that whoever buys and performs, that offer has been made to the whole world. And the term acceptance meant that whoever buys and performs as prescribed, you have accepted the offer. There is no need of communicating back to the other people. So what are we saying? That in the case of Carlill, an offer was made to the whole world, and acceptance was done by Carlill when she bought and used it in the way that was prescribed. So that is, in short terms, that is the whole scenario of Carlill. So we are saying an offer can be made to the whole world. Let me give you an example, colleagues. You might be at the law school and the lecturer asks you a question, puts up a question saying, for example, that the police advertised that whoever finds a serial offender, this rapist who raped, let's say, a 14-year-old, defiled a 14-year-old girl, whoever sees this person and reports them to police will award them 100 million. So the issue is, whoever sees and finds, that offer has been made in that advert, it is now to the whole world. Whoever finds them and report, you are given the 100 million. So that is the type of offer we saw in Carlill, a unilateral offer. It comes from one end and it is going to the whole world. However, to even cement it better was the consideration, the putting of $1,000 in Alliance Bank. It meant there was some bit of consideration, some bit of sincerity. So there is no way you say that there was no offer. An offer was made, and that case is very rich, that all the elements of a contract are embedded in that case. Let's take an example. Professor Ben, in his book, The Contract Law, he gives a very good example about a wording of wording of advertisement, how they can differ. Let's talk at what he says about the Mukwano industry. That Mukwano company advertised and said, whoever buys 20 cartons of soap will be given 1 jerrycan of cooking oil. And then 1,000 people went and bought the 20 cartons of soap, and then they were demanding for the 1 jerrycan. And then the manager said, for us, we have 200 jerrycans for those people who have bought. So the question is that in their wording, they should have said that the first 200 people to buy 20 cartons of soap will be given a jerrycan of cooking oil. That would be now the right wording. You limit. So while making some of these advertisements, you must be sure on which type of wording you're putting out there. Let's look at the case in Chimona versus departed Asian Departed Custodian Board, those houses. That they wanted to rent out, to lease out these houses, and they put up an advert that a bid, whoever bid and you were successful, you would pay 10% of that money. And then Mr. Chimona bids and even goes ahead and pays the 10%. And later they are telling him that we want to consider the occupants of these houses, and then he takes them to court. Court is clear that where in your wording you're clear that if you want to take this, do this, and you pay 10%. The fact that Mr. Chimona had paid the 10%, then there was a contract which you would not run away from it. So that is the difference of the wording. You must be clear. While you, as learning counsel, you must pay attention to details while reading these contracts, while reading these advert. So you see that in Chimona and in Carlill, the offer was open to the world, whoever, and your acceptance was by performance. But again, if you see in Chimona, they are limiting that only those who pay 10%. If you're successful in a bid and you pay 10%, then the houses are yours, which Chimona did successfully, and they wanted to change. So their wording landed them into problems. We have another concept that is called the invitation to treat. This one we shall expound, but I just want to pick on examples of adverts which are invitational to treat. They're only invitation to treat means the willingness to initiate negotiation, the expression, the willingness to initiate negotiation. That when you have something called invitation to treat, you are only calling person to allow them to negotiate. And in our next video, we shall do the display of goods, and then we shall look at the great pharmaceutical case. We look at Fisher versus Bell. But today, we are interested in the advert of Harris versus Nickerson. Nickerson put up an advert for the auctioning and put up some goods which will be sold at the auction. So on a certain day, certain time, all things were put up. So on the day of the auction, Harris goes with this, that I'm going to buy such and such goods because I saw them, they were put up for selling or auctioning. So on reaching there, the goods he had seen, the items had been removed, or probably they had been already taken or removed. So Harris is suing for waste of his time, loss of time, loss of time and all that. So court held that Harris, the goods he had seen in an advert, that was not an offer. That was an invitation to treat. They were calling him to come and bargain. An invitation to treat. We are calling you the willingness to express, to start negotiation, to start the bargain. So we shall look at the principles of invitation to treat in the next video. But in this video, now, when they put up things in an advert saying we are selling A, B, C, D, this and this on this date, you come and you buy, they are calling you. It is an invitation for you to come and negotiate. But the offer is given. An offer is a willingness to do. They are telling you, we have given you an offer. It is open. Whoever performs it, you have accepted it. We are now bound by your performance of the offer. So here in invitation, we are calling you, come and we talk. Come and we talk. The things are there. Come and we talk. When we reach on Great Britain and then Fisher Bell in our next video, it will make a lot of meaning. So that is the difference between these wordings, advertisement. You need to draw that differences, that some offer in the wording are given to the whole world, and then whoever performs it has accepted the offer, and some of them are invitation to treat. And I've given you examples of invitation to treat: display of goods in shelves. All those are invitations to treat. So we thank you so much, and we ask you to always subscribe to this channel for more and more and more videos. Thank you so much. Subscribe to this channel.